alternative. Maybe I should start again. Good afternoon and welcome to the Alternative Dispute Resolution Certification Working Group. And I just want to remind us all that we are being recorded. Angela, would you please call the roll?
Armstrong is absent. Coulter?
Here.
Dinkin?
Here.
Curtis?
Here.
Dubois?
Here.
Ellis?
Here.
Dr. Getz?
Here.
Higuchi? Hodgson?
Here.
Jones? Kelly?
Here.
Kopaken?
Here.
Cruz? Lowe?
Here.
Judge Lucky?
Here.
Halevsky?
Here.
Judge Pichon?
Here.
Robertson?
Here.
Tuckman?
Here.
Welch?
Here.
And Yamshawn.
Here.
You have a quorum.
Thank you. Next on the agenda is the call for public comment. State Bar staff will call members of the public in the order they appear in the attendee pool. Angela, would you please provide the instructions?
For those who are participating by Zoom video, you should have a raise hand function. Please use that function at this time to give a public comment. We will call on the public commenters in the order that we receive the raised hands. You will be allowed 3 minutes for each speaker. The on-screen timer will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. If you're participating by phone, you can use the star key and number 9 to raise your hand. All right, I do have one raised hand, Mr. Kai on. Kai, your mic has been enabled.
Good afternoon, all workgroup member. My name is Kai On from Sacramento. I would like to share an unusual incident about State Bar. Sacramento DA office and SPD provide me fake information about my father's death. They provide fake defendant Jung So Fong hit and run kill my father in DA case number 99F08735. Sacramento City Council even used a UC Davis internship student to email me fake police report. I went to UC Davis Law School. I submit a letter to the dean. However, UC Davis Law School did not help to uphold justice. I also complained Attorney General Mr. Robert Bronter and Sacramento DA Mr. Tienho because they did not investigate Sacramento Police Department and Sacramento DA office. However, State Bar closed my complaint without reviewing the DA case 99F08735 to confirm my father Wun Kong was the victim and Jung So Fong was the defendant that hit and run killed my father. State Bar did not take any action. All committee members, you serve State Bar because you want California has a healthy and integrity legal system. However, State Bar is helping to cover up a Sacramento law enforcement scandal. How State Bar is qualified to examine and regular licensed attorney in California. Honor Pichon, could you provide comment on this unusual incident about State Bar?
Mr. Kai, I appreciate your comments, and I'm sorry to hear about your father. But that's all I can say at this point. I did read your comments that you submitted in writing also. Thank you for that.
Please share the incident to all the other committee and all other legal profession in the California. I think they have the right to know about this incident because the local news and local NBC, ABC, and CBS, they refused to help me to report the case. There's some political power cover up some incident. Thank you for all your time.
Thank you, Mr. Ong.
Are there any more raised hands for public comment? I don't see any more raised hands, Judge Pichon.
Thank you, Angela. Next, we'll go to the approval of the minutes from the November 2025 meeting. Are there any corrections or modifications to the open session minutes? Hearing none, may I have a motion to approve?
I so move. And Angela, I'm here too.
Thank you.
Okay, and the motion was made by,
Ms. Cruz.
oh, Ms. Cruz, thank you. And the second?
Second by Daniel Yamshun.
Thank you very much. Angela, would you please call the roll?
Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois,
Yes.
Ellis,
Yes.
Dr. Getz. Dr. Getz, I see you said yes, you're on mute.
Yes.
Thank you. Higuchi, Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Hopaken,
Abstain.
Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Abstain, I was not present.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
Judge Pichon.
Yes,
The minutes have been adopted.
thank you. Next, we'll have the chair's report. And as before, I don't have a formal report to make, but there are a few words that I would like to say. And again, I would like to sincerely acknowledge the commitment and hard work of our members as we continue to fulfill our charge. Each of us has expressed different viewpoints at times, and through the process, I believe we've made really significant progress. Your efforts, as I said before, have not gone unnoticed, and they are truly appreciated. While our opinions may differ, we remain a team working toward the goals that have been set forth by the legislature. Most importantly, though, as we work to achieve this charge, we must continue to express our views with respect and keep an open mind and listen thoughtfully to one another. Also, we have to respect each other's time. There's a lot to go through today, and we can work through it all as long as we leave time for everyone to contribute. So next is the staff report. Mia and Alan, does the staff have anything to report?
Yes, Judge Pichon, thank you. Very briefly, I first want to echo your comments and thank the working group for your hard work and commitment to this process. As you know, we currently have 2 meetings scheduled for January 12th and 21st. We were contemplating adding a third, and you should have received a email holding January 13th. But rather than add a third meeting in January, we will have meetings in February. So we are going to release the hold for the January 13th meeting, and then we will be sending a poll out tomorrow to schedule meetings or poll for your availability for meetings in February. Thank you.
Thank you. Next, we have a report and possible action on the tiers subgroup recommendations. And in advance, I'd like to say thank you to our vice chair and also the lead of the subgroup, Dr. Getz, and also to the members of his group. I know how hard you all have worked, and I want to say thank you in advance. And that's to Dana Curtis, Paul DeBow, Diana Cruz, Judge Jackson Lucky, and Daniel Yamshun. Thank you all very much. And now I'll turn it over to Dr. Getz.
Thank you, Judge Pashan. I really appreciate that, and also the hard work of our subgroup members. I'm not going to, I think most of you were here for the last meeting, so you're pretty familiar with the process that the tiers subgroup went through to try to put forward some recommendations for the working group to take a look at. And we successfully got through 13 of them last meeting. 14th we sent back to the subgroup, which I will report on a little bit later in our proceedings here. But 13 of them, one with a small change, got approved. And please remember that we're talking about requirements for the different tiers and also electives for the different tiers. So the candidate will have an opportunity to pick from a series of electives. So when it's elective, it most likely went through our subgroup in a manner in which people could support it as long as it wasn't a requirement. We did reach general consensus on the rest that we're going to go through today. And then, like I said, we'll have some report on matters sent back to the subgroup. As usual, I'll ask Mr. Weiner to also help me out with this, as he's been in control with a lot of our written work, including the spreadsheets and everything else that we have as we go forward. So if you recall, we left off at the last meeting with concluding with item number 14 that's in our report. And we were about ready to move to item 15 and 16 under maintaining participant records. And so that's where we'll begin. And of course, as we go through these, I'm going to use the procedure I used last time, which seemed to help our discussion. And that is, you might recall that we were invited to participate in a platform called Thought Exchange, and many of you did so. And so I have some feedback from the Thought Exchange exercise that may be helpful for our discussion. And I'll introduce each item by going through the feedback from the Thought Exchange, and then also invite members of our subgroup to make any comments that they want. And of course, then open it up to everyone. Any questions before we start? Okay. Don't see any. So let's dive into number 15. So 15 is on maintaining participant records. Practitioner keeps records identifying the lawyers and parties in all ADR processes conducted after becoming certified. So since it was after becoming certified, it's not applicable for tier 1. As you might recall from last meeting, tier 1 is our baseline tier. That was the general requirements, and then required for upper tiers. On the Thought Exchange, we got general approval on this one. There was 50% as is with the language standing alone, 80% as is or if modified. And so then I looked on the Thought Exchange for what the suggested modifications were. And one of the modifications suggested including required for all tiers, so meaning required for the baseline tier. And another note that indicates that we should have a note indicate that does not modify any existing record keeping that may exist outside of the state bar. So with those notes, I invite any member of the subgroup, and of course, also then the working group to comment on this particular requirement for tiers. Okay. I'm not seeing any comments.
Yeah,
which...
it's
Katie Jones.
Okay, Katie, thank you.
And Ron Kelly.
Okay.
Thank you. Thank you, Ms. Dr. Getz. I had a clarification question. Is this They'll maintain records in all perpetuity after becoming certified. Say, we hope that this program lasts from here henceforth with, so 20 years down the line, they have to maintain these records, or can there be some kind of deadline consistent maybe with arbitration disclosures? So in a consumer arbitration, you have to disclose mediations going back 2 years and other arbitrations going back 5 years.
I think that's a great question. Mr. Weiner, did we have a discussion in the subgroup about limitations on this?
We did not.
Okay. Mr. Kelly, did you have comments as well?
I do. Thank you. As I read the requirements for mediators that we adopted, Rule 6B1 says a mediator must make reasonable efforts to keep informed about matters that could reasonably raise a question about his or her ability to conduct the proceedings impartially and must disclose these matters to the parties. And the statutory requirement for arbitrators has a virtually identical requirement in CCP 1281.9A. And so I think it's inaccurate to say that it's not applicable to the baseline tier. I believe to be able to make reasonable disclosures and to make reasonable efforts to keep informed about such matters, you would need to keep those records. So I think the NA is inaccurate on 15. And for what it's worth, so I don't have to repeat myself, I think that's true about 18 and 20 also. Thank you.
Thank you. Mr. Weiner, any comments on that?
Well, only that Mr. Kelly does accurately summarize the duty to remain informed and to make disclosures. The question, I think, is whether this requires keeping the records in 15, or whether there's some other way that the practitioner could stay informed and make disclosures. It does seem reasonable to think that some type of records would need to be kept. I would also note the next one, number 16, refers to maintaining attendance sheets, which is a requirement from the rules for court-connected mediation programs.
Ms. Cruz?
I think we should change the NA to R. I agree with Mr. Kelly. And after there's further comments from the group, I think that these are good to move for the group's acceptance or rejection as modified with the R.
And Ms. Cruz, how do you think there should be a limitation in terms of years?
I do, and I thought we actually did talk about the years in our subgroup. I thought we mentioned that they would be consistent with what's generally required of arbitrators and mediators in terms of the amount of time. So 5 years for arbitrators. I mean, frankly, I'm not sure that you would. I think if it's okay with the group, we might want to investigate that further. I wonder whether even beyond the 5 years, it's a good idea to just keep the names of people because of the impartiality comments that have been made. But at minimum, it should be the number of years that's identified in other statutes. And I can take that on, just looking at that quickly and then reporting back to the group if you'd like.
Thank you. Mr. Welsh?
Yes, Mr. Getz, thank you very much. Or Dr. Getz, excuse me. I just wanted to mention for the Dispute Resolution Programs Act that it is something that's been mentioned about confidentiality with individuals' names when it's presented information to the county. Like there is a restriction on information a county can hear on the kind of information of parties and who's involved. And so I just want to bring that up as something that's been voiced by other DERPAs about requiring, keeping information. I don't know that it's going to pause any of this at all. I think it could be a separate kind of dynamic. I just want to mention it just because it was brought up by other DERPAs in that context of keeping records of parties, etc. So I'm just making that comment.
Thank you. Mr. Yamshan.
Thank you. I was muted for a second. Realistically, I mean, it wouldn't hurt to set, I guess, something similar to a statute of repose where you would only have to keep records going back so far. But realistically, I doubt if anyone who would qualify for certification would keep paper records of past activities as a neutral. You're going to use a database, whether it's DBase or even Excel can be used as a database. And there's no point in having to go back, say, 5 years and purge everything before then. I think, practically speaking, once your database is started, these cases are going to be in there forever. I recently made a disclosure from an appearance by a law firm that took place 35 years ago. So it's still in the database, and I see no reason why neutrals would spend valuable time going back and purging database just because it's older than the statute requires. At the same time, it wouldn't hurt to set a time that the records must be kept.
Any other input?
Eric.
Mr. Tuckman is there.
Mr. Tuckman?
Thank you, Dr. Getz. Quickly, I am also in support. I think that all tiers should have a requirement that practitioners keep their records for the reasons that Mr. Kelly and Ms. Cruz indicated. Just in terms of the time, I also wish I could point to the authority, but something like 5 or it might be even 7 years is the appropriate time. But in terms of mandating that, we can just say if there is agreement that we want to have some minimum threshold, we can just say no less than 5 years or 7 years or whatever it's going to be. That allows for people to keep their records indefinitely if they wish to, but also life gets in the way. People move around throughout their lifetimes professionally, and it would alleviate some of the concern about losing data that way.
Thank you. Ms. Curtis, I saw your hand.
Yeah, I wanted to make a motion. So I don't want to cut off discussion if there's somebody else that.
I think you're good.
Okay. Well, there are really 2 things. I'll take them one at a time and somebody else can do it if they'd rather. But I move that number 15 be also included as a requirement under Tier 1 or under the basic requirements.
I will second that motion.
If I may, Dr. Getz, I just want to go back to the top of this document and provide the form of the resolutions. We weren't showing the resolutions for each one of these 26 tiers before, but the form of the resolution that we were using last time is resolved. The ADR Certification Working Group approves in concept tiers criteria number blank of 26 in attachment 1 to the December 15th, 2025 tiers subgroup report and recommendations for agenda item B21. And then it would be either as proposed or as revised during the meeting, and that it be distributed for public comment. So that would be the form of the resolution unless otherwise is requested or specified in the discussion.
Thank you.
I'm sorry, can I also ask, there was a move by Ms. Curtis and a second by, I didn't catch who seconded.
Paul.
Thank you.
Paul's vote.
All right. So, Ms. Curtis, I'm just asking as a follow-up. And do you propose making then a second motion after this as to the time period along the lines of what Mr. Tuckman suggested?
Yes.
Okay. And do you see that, could we possibly include it all in the same motion, or do we need two different resolutions on here?
I suggest we have two different resolutions.
Okay. Mr. Tuckman, did you have your hand up from before, or is that okay? All right. So, and Ms. Cruz, I see your hand is up.
Yeah, and just to speed this up, it's at least 5 years for arbitration. So I've already been able to verify that team while we're on the Zoom. I'm not as familiar with the mediation statutes.
Okay. And Mr. Weiner, just to double back with you, is it okay if it comes in two different resolutions, or do you need it in one resolution?
Well, I would only say that there's a roll call with all the members of the working group, for each vote. So if it can be accomplished in one resolution, that would be more efficient and I think fine from my perspective at least.
Ms. Curtis, does that work for you?
Yes, I'm happy to amend my motion.
Okay. And
Is
so
that okay with Paul?
Sure.
Okay. With the original, which was that we adopt this as a basic requirement. And then secondly, that for both arbitration and mediation, it be at least 5 years.
And then Paul, you seconded that.
Yes.
All right. I think, Angela, we're ready for you.
Okay, Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois,
Yes.
Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi, Higuchi, Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
thank you. Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
Yes.
Judge Pichon.
Yes.
The motion carries.
Thank you, everyone. Number 16, practitioner requests that all mediation participants complete attendance sheets containing their name, mailing address, email address, telephone number, retains the attendance sheets for at least 2 years, and upon request, submits the attendance sheets to the State Bar in any firm or program through which the mediator is performing the mediation. And this is for mediation only. And this, the subgroup recommended as a requirement at all levels. On the thought exchange, we had 70% approval as is, 90% if it was modified. The modifications that were suggested included less detail because of privacy concerns. So I'll throw it to Mr. Weiner. Any comments on this one?
Sure. Thank you, Dr. Getz. I would just note that this requirement is based on the rules of court for court-connected mediation programs, and that a version of those was also adopted by this working group in August as part of its recommended ethical standards for State Bar certified mediators. And that's why it was shown as required at all tiers.
Thank you. Any discussion from subgroup members or other members of the working group? All right, I'll ask one of my subgroup members to make a motion then. Ms. Cruz?
I'd move for the adoption and acceptance of this item.
We have a
Lucky, I'll second.
Thank you.
I'll take the vote. Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois,
Yes.
Ellis,
Yes.
Dr. Getz, Higuchi, Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Hopaken,
Yes.
Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Pileski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Abstain.
Yamshawn,
Yes.
Judge Pichon.
Yes.
The motion carries.
Thank you, everyone. All right, now we get to a series of requirements and electives under disclosure and recusal. Number 17, before accepting a new arbitration or mediation, the practitioner discloses the practitioner's policy about entering new professional relationships, including as an ADR practitioner, with parties and lawyers in a pending matter. As you'll see, there's a footnote there, similar to the current requirement of arbitrators in all cases, and there's a reference there. When we went to the thought exchange on this, we had 60% approval as is, 80% as is or if modified. The suggested modifications is requirement for all tiers. So as you note, number 17 right now came out of the subgroup as not applicable for the baseline tier. It also include one of you noted at least some thoughts as that the disclosure is just not enough. There should be more than disclosure. Mr. Prolevsky.
Yeah, I think it may be necessary to separate mediation and arbitration here, because as you indicated, it is already standard and required in arbitration. And in fact, if you do not affirmatively state that you will take new cases, you're prohibited from doing that. So I can't see how it helps in an arbitration context to make it anything other than required. Before we get to discussing the general ethics of it, I think it is required. Should be required. Unless we prohibit it altogether, which I think is a better solution.
Any other comments? All right. Any members of the subgroup want to address this? Ms. Curtis? I think you're on mute.
Cliff makes a very good point, and it seems to me that we need to clarify that it is a base requirement for arbitration, since it's required to bring it in line with the statute related to this for arbitrators.
So you'd be in favor of it as being a baseline requirement?
Yes, I would.
And does that apply to mediation as well?
Yes.
Okay. Mr. Yamshawn?
I don't want to be redundant, but basically I agree with Cliff and Dana that it should be required for all tiers in both arbitration and mediation.
Okay. Mr. Kelly?
I third that sentiment.
Ms. Cruz, I saw your hand up, but then No? Okay. Okay. Thank you. I just didn't want to miss you. Okay. Would a member of the subgroup like to make a motion?
I move that the item 17 on disclosure and recusal be modified to include the disclosure requirement for both arbitration and mediation at all tiers.
And Curtis, I second that motion.
Okay, Angela?
Armstrong?
Excuse me,
Oh,
before you do that, could I ask, is it necessary then to retain the brackets? Because those are just a bit confusing.
Oh, yeah, good point.
If
Just
I can
one.
speak to that,
Yeah.
Dr. Getz. Yes, Mr. Kelly, throughout we have the brackets arbitration or mediation, except if criteria would apply only to mediation. The plan being that where it says arbitration or mediation, it really means both. And what will happen is that after they have been adopted, there'll be separate tier documents prepared for arbitration and mediation. So just to explain why it's set up that way now.
Thank you for that clarification.
Yeah, otherwise it wouldn't make sense for the disjunctive to include the conjunctive.
All right, I think we can go back to the roll call then.
Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Dinkin?
Yes.
Dubois?
Yes.
Ellis?
Yes.
Dr. Getz?
Yes.
Higuchi?
Yes.
Hodgson?
Yes.
Jones?
Yes.
Kelly?
Yes.
Kopakin?
Yes.
Cruz?
Yes.
Lowe?
Yes.
Judge Lucky?
Yes.
Palevsky?
Yes.
Robertson?
Yes. Sorry.
Tuckman?
Yes.
Welch?
Yes.
Yamshan?
Yes.
Judge Pichon?
Yes.
Motion carries.
Thank you, everyone. All right, number 18. Before accepting a new arbitration or mediation, practitioner discloses whether the practitioner has served or is currently serving in any professional capacity, including as an ADR, as an ADR practitioner in any other matter involving a party or a lawyer in the prospective new matter. On the thought exchange, actually, most of you, 80%, said they would like to see it as is or modified, and the modifications centered on the fact that it should be required again for all tiers, and some belief that this was already approved by the working group in an earlier time. So, Mr. Weiner, I'll have you address this standard as well.
Yes, thank you, Dr. Getz. It was understood in the baseline mediator subgroup, I believe it was, that this would be a requirement, and it was an oversight that was not shown as required in the baseline, consistent with the principles that anything that's required in the qualification requirements or by statute would also be required in all three tiers.
All right, any discussion? All right, Mr. Palevsky.
I have a question about the timing here as it relates to arbitration anyway. That in a normal sense, there's a rank and strike, and the case manager goes to an arbitrator and says, would you accept this case? This is before the parties even know that the arbitrator has been appointed. So I'm trying to figure out whether this is intended to be an internal disclosure to the provider which may actually be a good idea so they don't get put on a list for people who they are already working for. I think that would be quite helpful. But if it's referring to the participants, they will have already accepted the case. And these kinds of disclosures are already mandated by the California Arbitration Act.
Okay, thank you. Ms. Curtis.
Yes. Alan said that the working group accepted this as a recommendation, but in fact, I mean, excuse me, that the subgroup did, but the working group actually approved this. This was just something that I should have caught earlier and mentioned it in our in our subgroup meeting. Ellen, do you agree with that?
Yes, it was a baseline mediator subgroup recommendation that was approved by the working group.
Okay.
If I may, while I have the mic, if I could just address Mr. Pilevsky's comment. I think the idea, I'm just not sure whether this tier subgroup for practitioners, arbitrators and mediators is the appropriate place to address not having this person be on the strike list. We do have the provider organization subgroup also making tiers recommendations. And I'm just not sure, and would defer to some of the provider organizations mechanically with a large provider organization, how would the practitioner be able to disclose to the provider organization that they have relationships and should not be included?
Ms. Cruz?
Just wondering again about timing, if we wanted to add that 5-year mark here as well, as that's what's required for arbitrations. It's for the past 5 years. I think, as Daniel mentioned, a lot of us just do it in perpetuity. So I'll tell you about something I did 20 years ago, but the statute says 5 years, so maybe we should add a limit to that. Or
Thank
maybe not for the group's discussion.
Thank you. Mr. Yamshan.
Thank you. I keep forgetting to unmute myself. Cliff, there may be providers that operate in the sense that arbitrators may be appointed prior to the parties receiving the disclosures, but not all. I think Dr. Getz can confirm that FINRA sends out an invitation. You make your disclosures, and then the disclosures are provided to counsel at the time that arbitrator selection is made. So these kinds of disclosures will take place during the arbitrator selection process. And with other providers, I've had counsel send follow-up questions after examining the disclosures. So I think that this makes sense. My only disagreement is it should be included with all tiers because people applying for certification will have some experience before they apply.
Thank you. Mr. Pilevsky?
Yeah, I agree with Alan. I didn't mean that this should be modified to control the provider's list selection. I just meant that I'm still not clear of how an arbitrator, before accepting a new case in the normal course, I just didn't know who you were disclosing it to. If you're disclosing it to the parties, they normally have accepted the case before that. I was just trying to work on the timing for this particular one.
Cliff, I think with many providers, the disclosures go out with the list. So they set a strict time limit as to when the neutral can provide the disclosures.
Right. So you're talking about these are disclosures to the parties.
Yeah.
But it says before accepting, but they've already, okay. But the acceptance is normally done internally. Isn't it right? So those of you who are with the big providers, don't you normally rank and then you present the case to the arbitrator and say, can we appoint you to this case? So the acceptance actually occurs before the parties even know about it.
Mr. Weiner?
Yes, Dr. Getz, I wonder whether this might be addressed by saying that at the outset of the case, and whether that might accommodate the different procedures. So would that work for the provider organizations? I'm just not sure of all the different processes that are used.
Anybody prepared to address that? Mr. Tuckman?
Thank you. So just in terms of when an arbitrator accepts a case at the AAA and ICDR, I won't give you all the different ways this can happen, but one big group of cases, the parties are party selected, and they've essentially come to us with their selection of an arbitrator, or it's 3 arbitrators. 2 party appointed arbitrators appoint a third. So they come to us, they give us the names, and then we send out our disclosure forms, and all the arbitrators complete those. Some of that information the parties might have already, but it provides some consistency and continuity. If it's a California case, they're going to get all the California disclosure requirements, and then whatever is sent to the AAA is going to be sent to the parties. That's the party appointed arbitrator process. So was the arbitrator appointed before we sent out our forms? We don't really think they've formally been appointed until they've signed their oath at a later time. If it's a list process, it is true that the organization, so each party gets the list, they strike and rank the people, the candidates, AAA, ICDR gets that list, they take the most mutually agreeable arbitrator and they contact them and they say, would you accept this case? And they'll say, yes. They may say at that point, and I think I was reading this as what was intended. They may say at that point, you're telling me who these parties are. I'm looking at the forms. Sometimes this is done online, by the way. It's not always a conversation, but they'll make the same disclosures. I've got a case. I had a case involving attorney X. Whatever that disclosure is, again, it goes to the parties, and they can either waive or they can object. So I guess I think it really is a timing issue. Again, I read appointment as sort of that final step after the disclosures are made. They've signed their oath. They're appointed at that point. They can actually go ahead, schedule a hearing. So I'm not as troubled by the word appoint. I think that at the outset of the case actually might introduce a little bit more uncertainty.
Thank you. Mr. DeBow.
Okay, well, I was on the AAA roster, and I did primarily employment arbitration, which is considered to be consumer arbitration. Bear in mind that there's different rules for regular commercial arbitration and consumer arbitration with respect to disclosure. But here's how it worked with me and with the employment stuff. I would get an email from the AAA asking me if I was willing to be an arbitrator in a case. All I know at that time would be the name of the case. By that I mean who the parties are and the names of their attorneys. I didn't know at that point, I had no idea of the nature of the complaint, whether it's a discrimination complaint, a wrongful term complaint, or something else. So I would say yes. If I said yes at that point. Once I said yes, I was sent the complaint. Well, I wasn't sent. I could get it on the website. I could get all the information about the case from the AAA website. And I knew much more. I would know the nature of the case. I would know and things of that nature, so that I could I would be more equipped to make disclosures. I couldn't make complete disclosures prior to that point. And then once, of course, I made a disclosure, assuming I still was willing to go ahead. Once I made the disclosures, then the parties had 15 days to challenge me based on those disclosures. And of course, if they so chose to challenge me, then I would not serve as the arbitrator. That's how it worked.
Thank you. Ms. Ellis.
Thank you, Dr. Getz. I don't think I have anything to add in terms of the process and the arbitration side, but I just wanted to note that in the context of, hypothetically speaking, an attorney who shows up to a mediation and you may not have been aware of at the time it was accepted, there could be some considerations with those types of scenarios. I also wanted to note that I agreed with Ms. Cruz's comment about putting a time cap or limit on this. Thank you.
Mr. Weiner?
Yeah, I'm wondering if substituting at the earliest opportunity for before accepting a new would solve the problem. I think this would address the concern about not knowing until somebody shows up for a hearing that they're going to be attending the hearing. The other thing I wanted to just observe, there's a lot of comments about the arbitration process, but in mediations, there isn't often quite such a formal process of appointments and disclosures that's been institutionalized in consumer arbitrations. And I think that saying at the earliest opportunity might account for the mediations as well as the arbitrations.
Thank you. Any other comments? So I'm hearing a few things here. One, I've heard that many of you might be open to requiring it at the baseline level. Also heard about the 5-year limitation, similar to the last requirement that we passed. Also heard Mr. Weiner saying changing the language before accepting a new to at the earliest convenience. Anybody from the subgroup want to make a motion based upon what we've heard? Ms. Curtis?
Yes. I also wanted to say that it actually was accepted by the working group as it stands, but I would move that we amend this particular provision to say at the earliest opportunity, practitioner discloses whether the practitioner has served or is currently serving in any professional capacity, etc.
And
Can I make another friendly amendment for has served for the past 5 years?
Ms. Curtis, would that be?
Yeah, it's fine. I'm just wondering if that's the way we want to state it. So let's look.
Maybe has served for the past 5 years, in the past 5 years.
How
Maybe
about within the previous 5 years?
I like it, Dana. I second.
And Ms. Curtis, in your motion, would you make this, as you noted already, you believe this already passed as the baseline requirement. So I assume your motion also includes changing the T1 base to required and not instead of not applicable. Am I correct in assuming that?
Yes, you are, Dr. Getz. Thank you.
All right. And Ms. Cruz, your second goes to that as well. All right. Thank you both. Thank you, everyone. Are we ready for a vote then?
Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Dinkin?
Yes.
Dubois?
Yes.
Ellis? Abstain.
Dr. Getz?
Yes.
Higuchi?
Abstain.
Hodgson,
No.
Jones,
I'll abstain.
Kelly,
Yes.
Kopaken,
Abstain.
Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Pulevsky,
Yes.
Robertson,
Yes.
Tuckman,
Abstain.
Welch,
Yes.
Yamshawn,
Yes.
and Judge Pichon.
Yes.
14 yeses, 1 no, and 4 abstain, so the motion carries.
Thank you very much, everyone. Mr. Weiner, ready to move on to number 19, or do we still
Could
need
you
some?
give me just 1 minute, please, Dr. Getz?
Okay.
Either as quickly as my keyboard skills will allow. All right, ready to move on. Thank you.
Thank you. Very much appreciate all the work you're doing behind the scenes to keep this up to date. So thank you so much. Number 19, practitioner declines to enter any new professional relationship with a party or a lawyer in an ongoing arbitration or mediation, including as an ADR practitioner, if at the outset of the ongoing matter, a party or lawyer so requests. So on the thought exchange, see, we had 40% agreed to it as is, 70% agreed to it with modifications. What were the modifications that were discussed in the thought exchange? One include, we need to define what the outset is. So you see that in the third line. Another wanted to make a 15-day window from the outset. And another asked about making it required at all tiers. Mr. Weiner, did you want to address this in general or any of the suggestions?
I would just observe that I believe at the outset of the mediation is referred to frequently in the rules of court for court-connected mediation programs, as well as in the ethical standards that the working group has approved. So I guess that's the only observation I have at the moment.
All right. Any comments from the working group or those of you who made comments? All right, great. Mr. Pulevsky.
Okay, a couple of things. First, I like the concept here very much. I appreciate it. There's a few issues that need to be worked out timing-wise again. And I also think it would be really helpful to us with these next two to have a larger discussion about the ethics of taking additional cases in general. But as to this particular 19 right now, the timing really matters because when the state bar, when the Judicial Council was addressing this issue, there was a notion that you can only take cases with consent. And it was rejected by everybody, including in public comment by the providers, because of the coercion, meaning you don't want the arbitrator asking for consent. So the outset here probably should be when the complaint is filed and when the answer is filed and before the arbitrator is appointed, so that it's not an issue of one party trying to impose something on the arbitrator. I think that's really important to avoid any coercion. And then what happens if you get a list of people and the arbitrator is then told that the plaintiff or the defendant doesn't want you to take additional cases? Does that arbitrator just quit the case because they want to continue making more money and not agree to that? or are they obligated to keep going? It's a really complicated question. Uh, and and I really think that there's some real negative consequences that can come if people who don't want to uphold that standard or that ethical standard say, I'm not going to do any more of these cases. So you're left with only people who need to take a case and are willing to do things that may not be as savory as it might be. So I think if it's going to work, it has to be before an arbitrator is appointed, and we need to understand what the arbitrator's obligation is. Will you accept it? Uh, uh, if someone says no, because that really can undermine the entire concept. But as we discuss these two things, I really, really think it's important for this group to at least have a discussion about the ethics of taking additional cases without consent. And I think you can take additional cases with consent if it's uncoerced consent and knowing and voluntary consent. But I believe that if the existing ethical rules and the most important ethical rules say you cannot have ex parte contacts, you may not, and you have to disclose all of your cases so that people can bump you if they don't like your disclosures. And the present ethical rules say you cannot act as a lawyer, consultant, or expert. And the present ethical rule is that unless you affirmatively tell people that you're going to take additional cases, you can't. I really think that this is a fundamental ethical problem. Not that you can't ever do it, but that the consent has to be obtained before the arbitrator knows about it. Meaning if two lawyers are on a case and one of them wants to use the arbitrator again, they simply need to get consent from the other party. The focus here is not on the new cases. The focus has to be on the poor, parties in the first case who have to sit there with their case or their lives in an arbitrator's hand, who then says, I'm going to take additional cases. Hundreds of thousands of dollars, 30 cases, 20 cases. There's no limit under these circumstances to how many cases you can take. And the only reason that this practice is going on now is because when the Judicial Council first created the rule, some exception was put in. That was nuts. I mean, it literally said you check a box and you can take as many cases as you want without even telling the other part. It literally said you don't even have to tell the other side. And we went back to the Judicial Council, and the furthest we could get with a 7-5 vote with the providers was that you have to tell people that you took the case, but taking a case in and of itself isn't cause. And I think the concept was that if you take one more case, okay, but that rule has been perverted, and the practice that is apparently going on now is that people are taking unlimited cases, and cause challenges are being denied. And I truly believe, and I realize this is hard because it impacts the present business practices and potentially finances, but it can't be ethical for an arbitrator who has to avoid the appearance of bias or not make someone worry about it to be taking thousands and thousands of dollars for one party, spending days in a mediation talking about baseball or whatever else we talk about. And I think that all of that, I think that concept needs to be addressed, more specifically than either 19 or 20.
Thank you. Judge Lucky?
Thank you, Dr. Getz. I saw a lot of hands up before mine, so I'll try to keep mine very short. I disagree with a lot of things, respectfully disagree with a lot of things that Mr. Pilevsky said about the neutrality of arbitrators taking on other cases. But and so I don't want my comments to seem like I'm adopting his position. However, I think a practical solution to 19 and his concerns would be to modify this to have the potential arbitrator or mediator put that into their disclosures, that they will commit to decline to enter into new professional relationship with a party or lawyer in an ongoing case. And then and again, presuming that these disclosures are coming out at an earlier time, which seems to be the model that some of us are anticipating, that the parties will then be able to decline to work with any uh, arbitrator or mediator who doesn't have this in their disclosures. And then that way, some of the pressure that Mr. Pileski is concerned about, that an arbitrator might or might not hold it against a party for making such a request. It's just that that becomes part of the arbitrator's disclosure, whether that's their policy or not. And then the party can choose to agree to that arbitrator or mediator or not agree to that mediator or arbitrator. It's not a perfect solution, but it might mitigate some of those concerns.
Thank you. Mr. Kelly. Mr. Kelly? Did you have your hand up?
Yes, are you hearing me now?
Yes.
Okay, thank you. One of the things that concerns me is if I'm in the middle of I'm going to talk about mediations. If I'm in the middle of a long mediation and then I find that um, the mediator has taken on 2 or 3 new cases with some of the same lawyers that are in the current one, then in the middle of the mediation, after I've already spent time and money, I have to decide whether I'm going to bump that mediator for a conflict, which, as I understand the rules we've already adopted, I'm allowed to do as a party. The mediator has to withdraw if a party says, I don't agree to what you've just disclosed to me, that you've now taken 3 other cases with one of the lawyers here. That puts the parties in a really difficult situation, potentially, of being mid-process, already having committed time and money, and only finding out about the fact that the mediator, in the case I'm thinking about, has just agreed to take a bunch of new cases with one of the lawyers. I don't know how we get around that, but it's not just a problem in arbitration. It might also be a very difficult thing for the parties in an ongoing long-term mediation. So I want to raise that issue.
Thank you so much. Mr. Yamshan.
Thank you. 2 things. I am of the thought that this should be required of all tiers. And second, and Cliff, I don't mean to give you the willies, because I think that you have a lot of valid points to make. But I think there should be an exception for party-appointed arbitrators, because one party shouldn't be able to disqualify the other party's arbitrator. That's all I have. You're welcome.
Mr. DeBow.
Okay, I might be a little long-winded here, but I want to first mention how, again, what goes on, at least in my experience as an employment arbitrator. There's a big difference. First, I also want to start out by saying I agree with Cliff that the parties have to know in one form or another if their arbitrator or mediator takes on a case involving a party in the, or attorney in the pending ADR procedure. But going back to as I started out here, there's a big difference between defense firms and plaintiff firms, at least in the employment area. And I suspect it's elsewhere. Plaintiff firms are smaller. They usually have one office and so forth. And I know, and defense firms are large, of course, but not only that, they may have an office in Fresno, an office in San Diego, an office in San Francisco. And I had experiences where I would be have a case where one of these large firms was defending the matter. Let's say it was the San Francisco office. And then I get a letter from the AAA, the new case, and it's the Fresno office of the same firm. In almost every case that I had, if not all of them, the attorney at the second division of the defense firm had no idea that I was involved in an arbitration with one of his or her partners from another office. And they didn't select me to influence me at all. That's how it works in my view. But I think the present system that we have, at least in arbitration, uh, works because arbitrations last a long time. And so what happens is at the beginning, we announce whether we'll take additional cases or not. And if we say we will, and that's uncomfortable to an attorney who's initially wanted to retain me, that attorney has 15 days to challenge me in the matter of the case. If he or she does not challenge me, then they know that it's a possibility that I might take a case from his or her adversary while the arbitration or mediation is pending. And that's the risk they take. However, I think the rule has to be that even in that latter situation, once I have notified and I choose to accept, whether I choose to accept the case or not, either way, I have to notify everybody that I've had this contact so that they know. And since they have agreed to take the risk, they can't challenge me at that point, but that doesn't they don't lose the right to try to vacate the arbitration later because maybe it turns out that that call I got was not really a nice. There was something about that call that made me unable to continue. So I think I would just go. I think this rule in that sense is unnecessary. Now, mediation is a little different, though. Mediations don't last a long time. Most mediations last one day. That's all. And there's preliminary stuff. If you're a good mediator, once you get the briefs, you talk to the parties for a period of time between the time you get the briefs, the time of the mediation session, to try to settle a case without a session. So but it's short. So I think, with mediation, I think you can afford a mediator can afford to say or be barred from taking new cases. But it's much harder for an arbitrator because the arbitrations last for a long time. I also did withdrawal liability cases. The minimum time I ever had was 5 years, and it's a limited bar. You said I'm not going to take a case from another lawyer in this bar, you're not going to get any more cases probably. So I think they have to rely on the uh, honesty and ethical ability of the arbitrator. He or she must notify the parties that they've had this contact and take it from there. I don't think uh, there should be a bar at all from unless except at the beginning when you make the disclosure and somebody doesn't want to have an arbitrator or mediator who's willing to take cases from their adversary while the case is pending. Thank you.
I
Thank you.
just want to remind everybody that the tier subgroup has until 3:30. That is the time given. I know there are a number of hands up, and I'm not asking that anybody not speak. Just if you would consider the time that you speak. Dr.
Thank you,
Getz.
Judge Bashan. Well, with that in mind, Ms. Jones, you haven't had a chance to speak on this issue, so I'd love to hear what you have to say.
Oh, thank you, Dr. Getz. To echo Mr. Yamshan's comments, I wanted to preface this that I certainly have not seen any of our arbitrators or those from other provider firms, letting something like repeat business sway them. But, as a little bit of opposing argument, if this is imposed on every group, and if you do believe that that's something that could sway an arbitrator, why would you not worry that they would be enticed to dismiss matters prematurely in order to accept further cases?
Thank you for that. Mr. Prolevsky.
Yeah, a few things. Keep in mind that there is an ongoing duty to avoid creating the appearance of bias or to make someone uncomfortable. Everyone's been talking about taking another case. The problem is people are taking 5, 10, 30, or 40 cases. And it's a completely different analysis. Can I take another case and can I take 30 or 40 cases? We've had several years now where this issue has come up and there's, as far as I can tell, no internal controls at all. I've never seen a motion granted for challenge for cause based on taking 30 or 40 cases. So it really isn't just simply saying, I'm going to take additional cases, doesn't disclose whether you're talking about one case or 30 or 40. There has to be some recognition that taking hundreds of thousands of dollars and having ex parte communications can create an unpleasant concern for the original party. Our job here is to protect the public. And I really do appreciate Judge Lucky and what Daniel's saying, and it's not my desire to impact anyone's economics, but this bar is only from the same party or the same lawyer. There's thousands of other cases out there. And the story that I told, this is not a story, in our subgroup, I was at a conference 2 weeks ago. A person sitting next to me is an arbitrator on the AAA panel and a mediator, in addition to being an attorney. He said to me, I had to disqualify 14 different arbitrators at JAMS because they all checked the box that said they would take additional cases, and I didn't want somebody. And we went on for 6 months before I simply gave up because they could not even identify somebody at JAMS who doesn't check the box. In the past couple of years, prior to however long ago, maybe Kim can advise, JAMS literally checked the box for the arbitrators, pre-printed it to make sure that no arbitrator checked the box that they wouldn't take it. This system is not working properly. There's nothing in this rule that protects against people taking too many cases or a provider organization where there are no real options because everyone's looking out for their own interest. I think we have to protect the public here. And I really think that I'm not suggesting that a complete bar is appropriate. I'm just saying that the original parties have to consent before one of them reaches out. I can tell you that as an attorney, if I have an arbitration pending and I know the arbitrator and I see the arbitrator at a party and an event, I will not go up and talk to that person. So I can't understand how an arbitrator who has a continuing duty to avoid the appearance can take additional cases and make additional money. You're not allowed to accept a gift, but you can take a $50,000 arbitration. None of that makes any sense. This is completely inconsistent with every other ethical obligation. And I'm afraid that we're letting the finances of the providers or the practitioners interfere with something that is so obviously a problem. And I just really hope that we can have a larger discussion about that because it is the one big sore, open sore, where it is creating problems. The industry has not regulated itself, and we're not talking about taking one other little case. And it's not working.
Thank you. Mr. DeBow.
Cliff, how about a limit on the number of cases you can take?
Tell me a limit and how much money you have to make from it, or how many hours you can spend having ex parte communications.
Well, Cliff, see, I know how you feel, but I mean, I think 99% of arbitrators don't even think about that when they get a second case from the same firm. It's just another case. They're going to get that, and they're not looking, oh, gee, I just got enough more money, so I can get more money from this law firm, therefore I'll rule in their favor in the first case. That doesn't happen.
No, but how does it
And
make the first person
I
feel?
understand, I understand your point. If I have 40 cases with firm X, it does look pretty bad, and I'll buy that. But one or two, three, I don't know what the number is. But how about a limit? Or another way of looking at it is that you can't take a case from the same person or the same office of a law firm, but you could take it, let's say, from the Fresno office if you have one in the San Francisco office, because there's no connection usually in those cases.
Well, maybe, Paul, two things. One is in every case I have with a big firm, they run arbitrators' names through a common database. They share experiences. And even if you're in a different city, I'm dealing with now LA, San Francisco, the big firms, share information in a database. But the only way to do this right is to not view it through the eye of an arbitrator who thinks they can be fair. It is through the eye of the original party who's learning that the arbitrator is spending days or making hundreds of thousands of dollars or even $50,000 or $60,000 from that same company. And the difficulty I'm having just even conveying this or having arbitrators acknowledge this sort of proves the point. And I don't mean to impugn anybody's integrity, but through the eyes of the initial plaintiff or defendant even. Like, I think if you actually ask people when they file their complaint or answer, how do you feel about the arbitrator taking unlimited cases from the other party? No one would say yes without knowing who's going to be taking cases. I just think it's a blind spot. And I think you can't view it through the eyes of the arbitrator.
All right. Thank you so much. Ms. Cruz, I saw your hand up. I guess I'm having a hard time, given the comments, coming up with a consensus of what the group is thinking. And Ms. Cruz, I'm going to invite you to make a comment and also put forward a motion, whatever, that may be in line with your comment. But I think we've probably spent as much time as Judge Prashant will allow us on this measure, and we ought to pull this to a motion. So, Ms. Cruz, please, any comments you have?
Yeah, I am very much opposed to this one because of a lot of the problems with gamesmanship at the outset of the ongoing matter problems that other people have raised. And also, lawyers move firms all the time. I've had that happen twice just this week, and it's only the 15th. And I gotta say, I think it's going to create a lot more problems than what it's worth, and people already have to disclose whether or not they accept new cases or not. So if you don't want an arbitrator who doesn't accept work from the same firm or party, then you don't choose those people. So my motion actually is to reject 19.
Yeah, Mr. Weiner?
Yeah, I was just going to note that, possibly a later version of this, if you will, probably not acceptable to Mr. Palevsky, but maybe a point to go forward. So right now, the requirement for an arbitrator to identify in their initial disclosures whether they will accept new cases from a party or attorney while the case is pending, and the subsequent right of the party to reject that arbitrator. If I'm not mistaken, that applies only to consumer arbitrations and not to non-consumer arbitrations, and does not apply at all to mediations. So if I'm correct about that, I wonder if it would at least be a step forward in the direction that Mr. Palevsky is proposing to extend that current obligation to non-consumer arbitrations and to mediations. That is a disclosure at the outset of the case about whether the arbitrator or mediator would accept new cases while the initial one is pending.
Ms. Cruz, is that you had the motion on the
Yeah,
is
well,
that
we already have that above, right? That we already voted on, that an arbitrator and a mediator in all kinds of cases is going to say to parties and lawyers, I accept new business or I don't, with the same overlapping parties, attorneys, or whatnot. So my motion is the same, that 19 is either unnecessary and or will create problems in pending cases if a party or a lawyer like basically force a neutral, notwithstanding their first disclosure, to chuck over new cases later on.
If I may, just to clarify, I think number 18 relates to disclosure of currently pending matters, not to future matters. So I think that would be the difference between what I offered as a possible concept on 19 and what was approved on 18.
Yeah, so 17 right above is I have to tell you I'm the type of practitioner who's going to do this or not going to do this. And then you as the consumer get to say, I don't like you if you do it that way or the other way. And I think that that is clean, it's upfront, it gives the consumer a choice and it gives the arbitrator a choice. But making it later down the line, there's a lot of permutations I can think of where things happen, like lawyers move firms, and all of a sudden, I have to tell you on my 5-year case that Paul was just talking about right at the end that I can't do it anymore because of this new rule, because I'll lose my certification. Maybe I'll try to get cases off my docket quickly, like Katie mentioned. I think the thought was well intentioned, but I actually think it's going to lead to a lot more problems in the end. And I think our back and forth and so many comments on this should at least give us pause.
I second the motion for the reason that it does not deal with party-appointed arbitrators.
okay? So a motion and a second. Ms. Curtis, you had something else you wanted to say on this?
I mean, I think I'm not in order, but I'm thinking that given the amount of discussion that we've had on this, that it would be good to take it back to the working group for more discussion. And I have a couple of ideas that I'd like to introduce, but I don't think that, that I'm in order here.
Well, maybe that's a friendly amendment. Ms. Cruz, would you accept that as a friendly amendment to take it back to the working group or take it back, excuse me, to the tiers subgroup for more work on this matter?
I mean, I defer to you, Dr. Getz. My position is this 17 kind of covers what we need to. And while there's a lot of creative ideas that we might have, I see problems with most of them in terms of allowing party gamesmanship after an arbitrator is appointed and has other cases.
Where did it do that? This is at the outset of the arbitration.
All right.
Yeah.
Go ahead, Ms. Cruz. I'm sorry. Didn't mean to.
Well, I know it is 3:30 and we do have a lot more other things to deal with. I defer to the group. If the group feels comfortable taking a vote now, we can. If the group would like the subgroup to go back and see what we can do, then we'll certainly put our great minds together and our cliff hats on and try to do our best.
Well, if you deferred to me, I would say I would take it back to the subgroup. But if you want to have a vote, I mean, I can't deny you the right to have a vote, but I'm not a guy who likes to vote the negative.
I'll withdraw my motion. Let's take it back to the subgroup and see what we can do, and maybe we can get a winner on our second try.
Is that acceptable to the rest of the working group?
It is to the seconder.
Yes.
Okay. All right. So number 19 goes back for more work to the tiers subgroup. Judge Prashant, we're at 3:30. Would it be okay to take up number 20? Because I suspect that's gonna be a lot of the same comments and we'll be able to.
Okay. Yes, that's fine. In fact, that's a good suggestion, Dr. Getz, to go ahead and take 20.
All
Then we'll
right.
be at a breaking point.
All right. I'll go to Ms. Curtis, who suggested 19 go back to the working group. Would you make the same suggestion as number 20 for number 20?
Yeah, especially given the time, I think it's a good idea to consider them together. Thank you.
All right. Do we have a second for that?
I guess I should say I move.
I'll second it.
All right. Any objections from the working group to take this back? 19 and 20, then go back to the tiers subgroup for more work. Thank you so much. Judge Pashon, thank you so much for allowing us the time. I realize we didn't get to everything. And if you think we should try to tackle some more, I'm more than happy to do so, but I wanted to leave it to your discretion.
Okay. Absolutely. Great, fantastic discussion. Great leadership, great participation. Thank you very much. We can always come back if we have time at the end. But at this time, I think we need to make sure that the other presentations have their time. So we'll take a 10-minute break for now. It is approximately 3:31. So how about 3:40? We come back and we'll start with the next presentation. Thank you. Thank you. And next, we'll move on to report and possible action on provider organizations subgroup recommendations. And ahead of time, like I did before, I'd like to thank the lead, Jenna Ellis of the subgroup, and all of the subgroup members for the hard work that they have done. And they include Dario Higuchi, Katie Jones, Kimberly Lowe, Cliff Pileski, Eric Tuckman, and Christopher Welch. Thank you all very much. And I'm going to turn it over now to Jenna Ellis.
Thanks so much, Judge Pichon. And thank you to the members of the working group and the subgroup. So this is the first time the provider organization is bringing recommendations for the full working group's consideration. And one thing that I wanted to note at the outset is that there are a few of us, and most of them are collectively on the subgroup for provider organizations that are affiliated with provider organizations, but our views and recommendations are our own, not those of the provider recommendations or provider organizations themselves. And so we are not speaking on behalf of our organizations, but just coming and bringing collaborative thoughts as ADR professionals from those groups. Our recommendations for you today really dovetail closely with those that were provided by tiers. And in fact, we have a very similarly structured chart to the one that we've just been looking at together for tiers, thanks to Alan Wiener, one of our fearless State Bar staff leaders. And so with that in mind, Judge Pichon, I actually wanted to get your guidance on whether it would make more sense for our group to cede our time to complete the tiers subgroups review. But that said, I'm happy to begin going through, but just wanted to double check because they are so similar in form and style.
Oh, okay. All right. Well, let me ask Dr. Getz if you would like to keep going. So your time would be over, Ms. Ellis, at 4:30. And then what would you like to do then? Make your presentation at the next meeting?
Whatever time allows. I think depending on how much longer Dr. Getz needs today, we can just seamlessly, I think, move right over to provider subgroups, at least for these tiers criteria that we're recommending. But yeah, whatever you prefer, Madam Chair.
Okay. Dr. Getz, what is your time estimate? Because I know you need to go up to number, what, 26?
Yes, and then we have the work we did as the follow-up that was referred back to us as a group. So it's hard to know how the conversation's going to go, but I mean, we could use 10 or another 15 minutes. Perhaps we can get through a couple more if that would work.
Is that what you would like, Ms. Ellis?
That would work great for me. Just to give you everyone a little bit more color, the provider subgroup does have many more meetings we intend to carry on with to continue work on the provider ethics standards that we're drafting and also administrative requirements for provider certification. So all we had today for you was tiers. And so I think that this will dovetail well.
Okay. All right. Well, let's, Miss Dr. Getz, if it's okay with you, keep going, and then I'll tell you about 4:15, and then check again with Ms. Ellis. Okay.
Thank you so much. Well, Mr. Weiner, I guess we need to pull our screen up again. So thank you for all your help, as always.
Of course.
Okay, so 19 and 20 were referred back to the tiers subgroup. Thank you for your input on that. Now we got down to we have two categories left, transparency and then advancing the field. In transparency, 21, petitioner informs the parties and lawyers at or before the outset of an arbitration or mediation where they can access the ethics standards for neutral arbitrators in contractual arbitration or ethical standards for state bar certified mediators and the complaint procedure for state bar certified arbitrators and mediators, and provides the name and contact information of the complaint coordinator for submission of any inquiry or complaint alleging that the practitioner has violated those standards. And it went through the tier subgroup as required at all levels. On the thought exchange, we actually had 70% approval, those of you who opined, 80% either as is or if modified. The modification would include, if there were modifications, there was some concern about the atmosphere it creates at the outset of the hearing or procedure, and wondering, and the thought exchange went on, wondering whether it could be at some other part of the arbitration or mediation. But as I said, 70% approved it as is. Mr. Weiner, any comments before I refer to our subgroup?
No, nothing. Thank you, Dr. Getz.
Okay. Any members of the subgroup want to speak to this? Mr. DeBow, would you like to speak to it?
No, I don't.
Okay.
Raise my hand.
All right, I'm sorry.
That's okay.
Any other member of the working group?
Diane?
Ms. Cruz has her hand raised.
Yeah, if you'd like, I can parrot Paul for you too. Paul raised the objection that, it's wouldn't be fun if you're a mediator or arbitrator to say, "Hi, I'm Diana, and here's how you file a complaint against me." But I think we talked about being intentionally a bit vague, right, with the at or before the outset. So perhaps a neutral could qualify for this by just putting it in their general kind of disclosure packet, right? With I'm on LinkedIn and here's how you file a complaint. And I also used to work as, a partner at MoFo, et cetera, et cetera. And the same thing for a mediator, right? Like when you send your confidentiality agreement. But many of us did feel that it is important to notify the public if you do have a complaint about who to call and where to go. So ultimately, with the flexibility that you could just put it on your website or put it in your opening packets, I would be in support of this.
All right. Any other comments? Thank you. Ms. Curtis.
Yeah, just one. There are going to be a lot of options, I assume, for places people can go to file a complaint, and each of the certified mediators, I guess, will need to choose where they want their complaints processed. So I think it's particularly important, since there's not one source, that there be a way for people to have information about that.
Thank you. Ms. Jones.
Yeah, so I was wondering if maybe we could include the practitioner and or their affiliated provider form provider service informs the parties so that it could be included in whatever paperwork the provider sends out. Because usually, procedurally, we do the communicating on behalf of the neutrals in advance.
Thank you. So I see, Mr. Weiner, you're looking to insert something?
Well, I'm waiting for further discussion, but I'm
All
poised
right.
to.
All right. Mr. DeBow.
Well, my problem with 21 is its timing. I just don't like the idea of when you first come are retained, your first meeting with the parties and their attorneys, you tell them how to file a complaint against yourself. It doesn't, I don't think it's a good idea. I agree with some of the comments made earlier today that it should be in the website and or some other form so that they are aware of how to file complaints. I also believe that if a party subsequently files a complaint against the ADR professional, that professional is obliged to tell the party or attorney how to file a complaint or where to file it. But I'm opposed to telling people at the outset of the relationship something which is basically negative about the um, professional himself or herself.
Thank you. Ms. Cruz?
I wonder, well, first, I love Katie's suggestion. And then second, I wonder, Paul, if you'd feel even more comfortable if instead of at, we just did before the outset. Because then it definitely would be part of the website, the forms, etc. I mean, you
Yeah,
do give people the option with the at or.
yeah. I don't mind. I just don't want to, most AER professionals, have a little short speech at the beginning of their relationship of how they operate. And I just don't want to, in that short speech, I don't want to tell them, and by the way, if you don't like what I'm doing, you can file a complaint, and here's how you do it. I just don't want to do that.
Yeah, Mr. Weiner.
Yeah, just a couple of comments. In terms of the suggestion about practitioner or provider organization, I just want to note where these tiers criteria would apply to certified practitioners who may be working for a provider organization that is not certified. And I just wonder if that may raise some concerns, and maybe we want to say, or the certified provider organization that they're affiliated with, just so that the provider organization is on kind of the same certification page, is one comment. My other is, at or before the outset leaves the flexibility to do it before the outset. But in some instances, for example, you may have a court program, a day of a court, where there's not an option to do it before. So have a concern about deleting the flexibility to make it either at or before. I wouldn't have a problem with reversing them and saying before or at the outset. Not sure that makes a substantive difference.
Ms. Cruz, how do you feel about certified provider organization rather than provider organization?
Well, I'm not sure I'd add certified, right? Because this is for practitioners, what we're doing. And so if you are going to rely on your provider to do it, then you're taking that risk if they don't. And I'm not sure they need to be certified themselves, right? They just need to do it if you're relying on them. And if they don't, you're on the hook for it. But I do like kind of the flexibility of making it more broad by just leaving it or provider organization. Like the AAA is going to do this like or they're not, and then a practitioner will know. But I would hate to not be able to rely on the AAA doing it, even if they chose not to become a certified provider organization. Does that make sense?
Yes, thank you. Ms. Curtis. You're on mute.
I'm not so sure we need to add provider organization. Isn't it implicit that we or our agents, whether it's an assistant or a provider organization, are going to supply this information? Just a thought.
Mr. Kelly.
Well, I agree with Dana, and I also agree with Paul's sentiment that if you're coming into the middle of warring parties as a mediator anyway, it's not the best intro to say, and here's how you complain about me. It's already a very difficult and highly charged environment. But I want to ask staff whether or not the comments I just heard, that if I post it on my website, that's sufficient. Is that sufficient to put state bar staff on notice that that satisfies this requirement? Is that our general feeling, and should we express that in some clearer way, or is the recording of this discussion good enough?
I think the discussion and sentiment in the subgroup was that it takes more than that. In other words, you can post it on your website. You can certainly refer them to the information posted on your website. But to simply leave the parties who may have a complaint to, their own devices to find out whether you have on your website information about how they can raise a complaint or not, I think doesn't accomplish the intent that was discussed in the subgroup.
Well, then, if I may, I'd like to suggest we clarify this a bit as a working group. Thank you.
Thank you. Judge Lucky?
My concern with this is I don't know of any other profession that would require this. Medical doctors, psychotherapists, marriage and family therapists, lawyers. It seems, and again, I don't know that I'm necessarily against it, but I don't know how many other professionals have to label themselves like a cigarette package saying this is I'm dangerous and this is how you complain about me at the outset of the relationship. And so, although I understand that that neutrals are in a different position than lawyers and other professionals, I don't know of any other certification process, and there may be one. I may be just entirely ignorant, but I can't think of another profession that has to say at the outset to be certified in any manner to say, please, here's how you file a complaint against me before we even get started.
Thank you, Judge Lucky. I will note just some of the professions you mentioned are actually licensed by organizations such as the State Bar or, the State Accountancy Board or the Medical Board. So it's more obvious as to where to complain about those professions. But your comments are well taken. Ms. Cruz?
Well, if the website doesn't work, I would be concerned about this, or the paperwork alone doesn't work, I'd be concerned about this. Then, based on Alan's point, one thing that Paul suggested, to go back to Judge Lucky and Ron's point, is maybe if asked instead of at or before the outset. That was something that our group also discussed as a potential. So if you're asked, then here's where that's kind of how it worked in court. Like, if asked, it's like the complaint forms are out there. I'm telling you exactly where to find them.
And again, I didn't hear Mr. Weiner, but I'll let him address it, say that the paperwork couldn't accomplish this. I did hear him say the website alone could not accomplish it. Mr. Weiner?
Yes, I think that is correct. I did anticipate that paperwork could refer somebody to the website that would have the details about who the complaint coordinator is, et cetera. I just also note, I think part of the spirit in which this was recommended by the subgroup was that the statute is supposed to be about accountability and consumer protection. And this is one way of affording that, not by requiring or by not requiring the parties to go looking around. And also in the earlier subgroups, we heard a lot of suggestions that various things shouldn't be required, but that the focus should be on transparency. So I think, again, that's sort of some of the sentiment that was underlying the subgroup discussion.
Mr. Kelly?
I recall the ethical requirements say we have to designate somebody. So plainly, it doesn't make any sense to designate someone without telling anyone who it is.
All right, any other comments on this? All right, well, I would invite a member of the subgroup to make the motion, and when you make the motion, address the for provider organization. I will make a comment before that right now the burden is on the practitioner when the insertion or provider organization seems to shift the burden a little bit. In my mind, if the practitioner is required to, then they're required to, if their provider organization is in fact supposed to do this for them, then the practitioner right now needs to follow up on it. When we insert or provider organization, it puts that, in my mind, in some doubt. Would a member of the subgroup want to make the motion on number 21?
Lucky, I'll make the motion and I'll suggest that we delete or provider organization and allow the provider group to examine whether that would be a responsibility of the provider group. But again, if we're going to do this, I agree with Dr. Getz that it should be non-delegable.
Do we have a second for Judge Lucky's motion? I will second.
Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Can we have some
Dinkin?
discussion, please? Can we have some discussion, please? I'm concerned about independent practitioners, those who take ad hoc cases, and there are more than one. And in terms of, because we're kind of assuming that everyone in every case gets assigned by a provider. And there's oftentimes that just parties stipulate to use a certain neutral, whether for mediation or arbitration. I realize part of this is going back to the providers group, but I can't imagine that the providers would be willing to take on the responsibility of just being a general recipient of complaints. So I think I'm not sure that this is really ready.
All right, thank you. Any other comments? Okay, let's resume the vote.
Dubo?
No.
Ellis?
No.
Dr. Getz?
Yes.
Higuchi?
No.
Hodgson?
No.
Jones?
No.
Kelly?
Yes.
Kopaken?
Abstain.
Cruz?
No.
Lowe?
No.
Judge Lucky?
No.
Pilevsky?
Yes.
Robertson?
Abstain.
Tuckman?
No.
Welch?
Abstain.
Yamshan?
No.
Judge Pichon?
Yes.
7 yeses, 10 noes, and 3 abstain, so the motion fails.
All right, thank you. I'm not sure how our consumers are going to figure out where they're supposed to haven't filed their ethical violations if there are any. But in any event, we'll
Well,
move.
Jack,
Yeah.
let's put that on our agenda for the next meeting of the tier crew.
Thank you. Okay.
It could be fixed.
Okay. Number 22, practitioner discloses the number and/or percentage of arbitrations or mediations the practitioner has conducted in subject areas specified by the state bar. So this is an elective only, and this is, I believe the subgroup approved this with the idea to give the consumer more information where available about the practitioner. Mr. Weiner, do you have some comments on this?
I would just add that the concept was that the state bar would have a list of different areas that the practitioner could indicate they have X number of cases in. One of the comments in the thought exchange was about what if there's a practitioner who has cases in a different area, and would suggest an other describe line might address that concern.
Thank you. Any comments from members of the subgroup? Mr. Yamshaw, is your hand up for this one?
Yes.
Thank you.
My concern isn't really for the working group as much for the state bar group that will specify, because there are some pretty arcane areas that should be included. Plus, there's subjects of certain broader areas. I raised the point of scope of work issues in construction cases, completion issues, things such as that. They are separate issues within the overarching field, and rather than having someone claim construction case and contract case, because there are also contract cases, they should be able to have a provision for those kinds of sub-issues, because they can be very important when counsel are looking for selecting the neutrals. And this is more of a directive to the state bar than the working group.
Thank you. Mr. DeBow?
But my only concern is use of the term percentage, because that could be misleading. I mean, if I only had 10 mediations and I had one mediation in a certain area, I have 10% of my total, but it's only one mediation. It's not very helpful to the consumer, who will think have some knowledge when I only tried one case. So I don't like the idea of percentage in there. If you want to use, I understand also that if you do a lot of cases, it's hard to keep up with the numbers. So maybe we could amend it to that you can only use percentage if you've actually been an arbitrator or mediator in a specific number of cases, so that the percentage is meaningful. But when it's not, when you haven't done very many cases, percentage can be misleading.
Okay. Mr. Weiner?
Yeah, if I can just speak to that, I think suggestions are welcome on this. The challenge with going with strictly numbers was how often is that updated and how is it updated? And that was kind of like an percentage area of practice was the option to try and address that. But I think your suggestion, Mr. DeBow, might be a better way of doing that, to have a minimum.
Just for your information, Alan, I can tell you right now how many cases I've arbitrated and mediated, because I have a database. Press one little button on my database and it'll tell me.
Thank you. Mr. Prolevsky?
But just some definitional things. I agree that the percentage is the or percentage doesn't really help, because it's a percentage of what. Also, we're not sure how we're defining conducted arbitrations. In other aspects, we're talking about having not worked through discovery so much as made a ruling or issued an award. and I think that there's some ambiguity as to what that may mean. I think it's important for arbitrators or mediators to answer those questions, but in the abstract, I don't know how helpful it is without more definition. And I think that those are two confusing issues, which would be good to clarify.
And just a mention, these are electives for tier 2 and tier 3. So presumably nobody would have completed just one arbitration or one mediation, since that would not even meet the baseline requirements. So while I understand the philosophical point, I think also it might not be as confusing when you accomplished tier 2 or tier 3 and done a number of arbitrations and mediations. So I just wanted to make sure everybody understood this is elective at a higher level. Any other comments? Any member of the subgroup want to put this up for motion?
Ms. Curtis's hand is up.
Ms. Curtis?
Yes. I move that, as modified in the following way, that we accept this item 22 as an elective. Practitioner discloses the approximate number of mediations the practitioner has, conducted in subject areas specified by the state bar. I'm leaving out arbitration because I think there's more work to be done.
And what do you do with percentage?
Take it out.
Take that out. So you're taking out and or percentage of arbitrations and mediations. So this is a mediation only elective?
Right.
All right. Do we have a second for, thank you, Mr. Weiner. Do we have a second for Ms. Curtis's motion?
Lucky, I'll second.
Okay. Any further discussion? Okay. I think we're ready for a roll call.
Well, Mr. Yamshan's hand is up.
I'm sorry.
Okay, thank you. I keep forgetting to unmute myself. I am reluctant to deprive the elective for arbitrators, whether it or not we have percentages, if total number of arbitrations might be acceptable. But if you look at the required categories and the available electives and the elective requirements for the at the bottom of the page, requiring 5 electives and having 11 available, or which would bring it down to 10, or 4 electives required and only 6 available. I think it really creates a bit too much of a burden. I think that experience counts for a lot. It's definitely one of the criteria that's used in the selection process. So I think that limiting it to mediators is doing a disservice to arbitrators.
Mr. Yamshan, would you like to propose a friendly amendment?
Yeah, the number of arbitrations or mediations the practitioner has conducted, period.
I'm sorry.
And the reason I would strike in the subject areas specified by the State Bar, I've already voiced my concerns about that issue.
All right. Ms. Curtis, do you accept that?
No. I mean, I think that there should be an elective for arbitrators. It's important. I just think we need to think about what does it mean? Just I might have someone said, what is an arbitration? Is it a evidentiary hearing? What is it? So does it go to an award? So I just think it needs more work, and I was only suggesting this narrow requirement, or excuse me, option, so that we could, as the tiers subgroup, think about it more deeply.
And I'd like to be clear that I seconded the exact motion that Ms. Curtis made, and I think that it's appropriate to deal with arbitration later for the same reason she said.
All right. So if I understand correctly, then the number of arbitrations will go back to the tier subgroup for consideration of a proposal. Am I correct in understanding that?
That was my intention.
Okay. Thank you.
All right. So the motion on the table that's been seconded is the highlighted one, Mr. Wiener's highlight, right? Does that make sense? Everybody see that? It has to do with mediations only? All right. Any other discussion? Okay. I think we're ready for a roll call.
Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Dinkin?
Yes.
Dubois?
Yes.
Ellis?
Yes.
Dr. Getz?
Yes.
Higuchi?
Abstain.
Hodgson?
Yes.
Jones?
Yes.
Kelly?
Yes.
Copagan?
No.
Cruz?
Yes.
Lowe?
Yes.
Judge Lucky?
Yes.
Palevsky?
Yes.
Robertson?
Yes.
Tuckman?
Yes.
Welch?
Yes.
Yamshan?
Yes.
Judge Pichon?
Yes.
The motion carries.
Thank you. Judge
Okay.
Pichon, thank you so much for the additional time. I think this is probably so that we can get the rest of our agenda in. This is probably a good time to send it back to you.
Okay, great. Thank you, Dr. Getz. Ms. Jenna Ellis, can you tell me what you'd like to do? Do you want to make your presentation, or do you want to yield the rest of your time to Dr. Getz's subgroup?
I don't want to. I know Dr. Getz has been facilitating conversation for quite some time, so I'm happy to jump in for 13 minutes if that sounds correct. Mr.
Yes.
Kelly, did you have a question? You're on mute.
You're on mute.
Sorry, thank you. I just wanted to understand what the term in brackets, California-based, meant in the subgroup's view, and it applies to most of these. Thank you.
Thanks, Mr. Kelly. That's a great question. At a previous working group meeting, we discussed that at the moment, the statutory language for California Business and Professions Code 6173 requires providers to direct all of their arbitrators and mediators to apply by these ethics standards, even if they have no connection to California. So the group, I don't think that we put forward this recommendation yet, but we'll be recommending and asking that the state bar seek amendment of the statute in order to more appropriately limit it to requiring California practitioners to abide. And so the language in brackets is just to acknowledge and memorialize that interest of the subgroup.
And you don't think it's appropriate for this working group to make recommendations about how to do that, how to decide what a California-based mediator is? Just leave
We have been exploring this question in the context of the provider ethics standards that we've been putting together, but I do think it's a really important question, and I do think it's something that the full working group should consider, especially because as it stands now, the ethics standards for neutral arbitrators in contractual arbitration, I think, are really good at laying out when they apply. And I think it would be prudent of the working group to do something similar for the mediator ethics standards and include some sort of application for them as well.
Thank you so much.
No problem. I appreciate Mr. Kelly diving in with questions. Does anybody else have questions? I wanted to share, depending on folks' interest in talking about certain items, I'd be happy to see and explore if there are specific tiers criteria you want to discuss. I'm thinking we could try to vote them all together. But before we do that, just to give you a little bit of an overview here, numbers 1 and 2, provider organization requires panelists to comply with applicable ethics standards. Provider organization has procedure to remedy its panelists' failures to comply. We, as the subgroup, agreed that those are generally, particularly number 1, required by the statute itself, and we felt comfortable that this would be appropriate for baseline certification as well. And the same is true for number 3, where we state that provider organizations will require their panelists to complete the ethics training requirement for initial certification for ADR processes, which is currently 2 hours. As you can see, there is one other, if Alan, if you wouldn't mind scrolling down, that the subgroup thought would be appropriately required at the baseline, and it's 1 hour of ethics training for all case administrators and marketing staff at provider organizations. The majority of the other tiers items listed actually do relate to, I think, a portion of what Dr. Getz was next on the tiers agenda, but relates to education and betterment and training. And so you can see that some of these we've suggested should be required at the higher tiers, and some should be electives, but focus on either requiring panelists to complete training or offering live ethics or ADR skills training, both to panelists and also to others. And with that live, you can see it's asterisks, so we do have a definition of live. The goal with live is just to say that if you have a recording that, say, the provider organization recorded in 2023, it would not count towards these sessions, although they can be recorded. Anyone? Ms. Cruz?
I was just wondering, don't we want to encourage them to do both live and recorded training, especially for people who aren't available or who are working 3 jobs or have a bunch of kids? Like, don't we want to encourage? I know we definitely want to do live too, but don't we want to encourage them to do recorded too?
I agree with you. I think we do. The way the subgroup was thinking about this is we perhaps wrongly assumed that anytime these live recordings are done, the provider organization might be motivated to record them and, have them otherwise available for the panelists in particular, but also for others. But does any other member of the subgroup want to weigh in with thoughts? Thank you for your comment, Ms. Cruz. As we continue to meet, we'll also add that on the agenda as a possible tiers item too. Awesome. Any other questions, concerns, either from members, any other comments from the subgroup members or otherwise? Mr. Kelly?
It's an overall question. I've taught mediator ethics and arbitrator ethics for a long time, and trying to come up with something new that would be 2 hours every year, that'd be quite the challenge. Is that what's contemplated generally, is a new ethics training, so that I can't just take the same one over and over again, which is kind of boring, but trying to come up as a trainer with I don't know, 10 different 2-hour ethics trainings, that'd be a real challenge. Is that what's being contemplated here?
I think that's a great question, Mr. Kelly. Mr. Weiner, could I get your input on this question in particular?
Sure, thank you. I think part of what the idea was here was to incentivize the training, providing training. I don't think the content, there wasn't a discussion that the content would need to be new. There was a discussion that some provider organizations, every time they do a training, they do record it and they have an online library of trainings. And the thought was that that didn't really incentivize putting on new trainings. And so that was the concern there. But there was not a discussion about how much of the content needed to be new.
I tend to agree with you, though, Mr. Kelly, in terms of coming up with new content. So I appreciate your comment on that point. Ms. Cruz?
I was just gonna say, I mean, I agree with Ron, although it's important that things be updated too, right? So maybe using the word updated would kind of help both Ron and the providers to not just regurgitate the whole kit and caboodle from last year, but to also add the new stuff from 2025.
I think that's a great suggestion. So I think we can do one of two neat things now. I could invite my subgroup members to see if anybody's interested in moving for all of these to be entered, or in light of the comments we've received, we could take it back and come back in January. Sarah? Ms. Hodgson?
Yes. Hi. I just had another comment. I didn't want to detract from the training discussion, but since we're kind of moving on, I did have a question about number 11 that's on the screen, as far as it's not applicable for the tier 1, and then it's elective for tiers 2 and 3. And I was wondering if there was any discussion at the subgroup level about how that complies with the language of the code section.
That's a great question. So my understanding from the complaints and remedies group is that those cannot be addressed by the provider organization themselves. They would be referred back to either the state bar or an organization identified by the state bar as someone who can handle these complaints procedures, to consider the complaints. And so an internal procedure to address complaints by a provider organization would be an above and beyond what is required by the statute, as an additional or alternative step that they could make available to parties, lawyers, and law firms who might want to raise a complaint.
Okay. It confuses me a little bit as far as sending a mixed signal, as far as I don't want you to handle your own complaints, but you can also handle your own complaints. But I appreciate that the working or the subgroup considered it and included it here for discussion.
And I think that's a fair point too, Ms. Hodgson. I think one thing that's on the minds of provider organizations is I think that at least the subgroup members is an interest in the fact that complaints and remedies for state bar certification relate to state bar certification. And so having this alternative internal complaint process also perhaps allows the parties an opportunity to, explore and work with the provider organization to address the complaint.
Thank you.
Mr. Weiner?
Yeah, I was just going to say, for clarification, I think it's written somewhere that the working group has acted on that provider organizations can have informal complaint procedures internal. They just can't discourage the use of the more formal external state bar approved procedures. So that was, I think, what the subgroup was thinking of when providing us elective credit for having an internal procedure.
Thanks for articulating that better than I did, Mr. Weiner. Ms. Kopaikin?
I guess I may be misrecalling. I'm recalling something quite different than what Alan said. So I'll go back and look. I don't want to eat up everybody's time right now since you're not asking for it to be voted on. And I was just perhaps when we come back, you could explain what you, Ms. Ellis, you were talking about how it could be as an alternative to, and I guess I'm still a little confused by that. So I think this is something I would be interested in hearing more about as well. Thank you.
Thank you. No, thanks for flagging that. Dr. Getz?
Yeah, just a question, and maybe I'm just not reading this the right way. Is it possible we would have a certified provider organization that doesn't have to inform clients, disputants about the state bar complaint procedure? Because I see it here as only an elective. I don't see it as a requirement, but are we really? I mean, I guess I'm asking out loud. This is a consumer accountability statute, consumer protection statute. Are we really going to certify organizations without requiring them, or are they required otherwise to somehow inform people of the complaint procedure?
So right now, the ethics standards that the provider organization subgroup is working on would require provider organizations to include information on their website about how a consumer could file a complaint with the state bar in furtherance of the complaints and remedies process for state bar certification. And so the idea of offering an internal procedure to address complaints would be something, and I think Ms. Kopaikin, I appreciate that she flagged that I used the word alternative. It wasn't my best use of terms there, but almost in addition to, in addition to the state bar complaints and remedies processes available, another mechanism by which a complaint could be raised.
Thank you.
Ms. Jones?
Oh, in the furtherance of keeping to our time, I wanted to make a motion to adopt the items that were marked as baseline required. So that would be numbers 1, 2, 3, and 14. Given we have some conversation left for some of the other ones, it looks like.
Thanks, Ms. Jones. Would anyone like to second?
I'll second. That's Ron Kelly.
Thanks, Mr. Kelly.
I'm sorry, would you kindly repeat what the motion was? I apologize. I missed it.
Certainly. Motion is to adopt the items that are listed as baseline requirement on the subgroup recommendations, which is items 1, 2, 3, and 14. 1, 4.
Thank you.
And we have a motion and a second. Ms. Ellis, would you like for roll to be taken?
That would be great. Thank you, Your Honor.
Armstrong is absent. Coulter?
Yes.
Curtis?
Yes.
Dinkin?
Yes.
Dubois?
Yes.
Ellis?
Yes.
Dr. Getz?
Yes.
Higuchi? Hodgson?
Yes.
Jones?
Yes.
Kelly?
Yes.
Kopaikin?
Yes.
Cruz?
Yes.
Lowe?
Yes.
Judge Lucky?
Yes.
Pilevsky?
Yes.
Robertson?
Yes.
Tuckman?
Yes.
Welch?
Yes.
Yamshan?
Yes.
Judge Pichon?
Yes.
Motion carries.
Ms. Pichon, Judge Pichon, it's 4:33, so I would turn over my time on my topic.
All right. Ms. Jenna Ellis, thank you so much. Great presentation. And the rest will return for presentation at our next meeting. So now we're going to move to the final item, which is report and possible action on application of State Bar certification program and complaint procedure for court programs. And we spent quite a bit of time on this at the last meeting. There's been written information given to the entire group so everyone could be prepared for today's discussion. And that's why I have asked the presenters to take only 5 minutes each, and that has to be strict so that the group can now weigh in on this process and procedure. So we'll start with Ms. Kopakin, and Ms. Kopakin and Ms. Hodgson. If you both wish to present, you'll have to split 5 minutes. So who would like to go first?
I'm going to defer to Ms. Hodgson.
Thank you, Ms. Kopakin. In the interest of being as efficient as possible, I'm going to read from my notes. So I apologize for not being a particularly engaging speaker. Basically, as you may recall from our last meeting, one of the things that is the pinpoint or the underpinning of Ms. Kopakin's and my proposal is that the State Bar is not required to have a complaint procedure, while courts that have ADR programs are required to have complaint procedures. And I think, as we have discussed in some of the other topic areas previously, the onus is on the practitioners and providers to have some sort of a complaint process in place. The language of the statute says that. The State Bar staff and their Office of General Counsel have apparently interpreted the statute to require it to create a complaint process, and as such, that court-connected complaints cannot be exempted. However, the statutory language very clearly does not require that. It requires certified firms, providers, and practitioners to have procedures in place to make complaints and procedures to remedy failures. Meanwhile, court complaint processes are expressly mandated by statutes and rules. Our proposal there, I want to be very clear on this because I think there has been some confusion. Our proposal is not to exempt court-connected complaints from any complaint process, but instead to acknowledge that with respect to court-connected ADR, the practitioner has, through our mandated court processes, a complaint process and procedure to remedy failures. So they are in compliance with Section 6173 solely with respect to court-connected ADR. And as a somewhat related aside, I think Ms. Cruz raised this last time, we're talking about a very small number of complaints, I suspect. As I mentioned last time, and as Ms. Kopakin mentioned last time, the State Bar has no authority or jurisdiction over courts. The materials that have been previously attached and that were attached today talk about entering into an agreement with mutually agreeable terms. Our concern isn't fixed by calling it an agreement. That does not mean that the State Bar is not effectively exercising authority or supervision over courts. To enter into that kind of agreement, it's clear the State Bar would review a court's complaint procedure to confirm it complies with the State Bar's requirements, which is inherently an exercise of supervision and authority over the courts. Calling an agreement does not cure the issue. Additionally, any requirement that courts disclose complaints potentially violates Rule of Court 3.871 that specifically instructs the presiding judge or their designee to use their discretion regarding disclosure of complaint outcomes. Requiring disclosure removes all discretion the rule of court entrusted to the presiding judges and their designees regarding the propriety of sharing any particular complaint outcome. To my knowledge, Ms. Kopakin and I are the only two people on this working group with experience running court ADR programs. And with that context, we have concluded that the State Bar's current proposal is untenable. And we continue to try to share that experience and that concern with both State Bar staff and now with this working group as a whole. We also wanted to note that after the prior meeting, there was a public comment by another ADR program administrator, Ms. Emerita Alvarado, whose comments also concurred with what Ms. Kopakin and I have been saying. And we note that courts have not yet been consulted for any sort of official input. And our final point that I just want to raise, although my hope is that our proposal will be accepted, that if neither of the proposals is agreeable to this working group, perhaps it would be appropriate to ask the legislature to clarify whether the statute was meant to replace or impact existing court processes as the proposal by the State Bar would do. I believe this idea has been proposed on other issues and may be appropriate here.
Thank you, Ms. Hodgson. Mr. Weiner?
Yes, thank you very much. I appreciate the concerns of the courts and of Ms. Hodgson and Ms. Kopeikin. I just want to clarify that I do have significant experience working with court ADR programs in the state of California for a dozen years, including developing the rules for complaint procedures and the ethical rules. I think that the state bar and the courts share an interest in consumer protection, protecting the public, where mediators or arbitrators have failed to adhere to the applicable ethical standards specified in the statute and those that the state bar adopts in accordance with the statute. I think that the rules of court, particularly 3.871D, does specifically contemplate that the presiding judge can authorize the disclosure of information, and it would be counter to the consumer protection objectives of the statute. And I would submit also goals of the courts and the state bar to have complaints adjudicated about a mediator or an arbitrator, and the other doesn't know what has happened. And so they remain a certified practitioner on the state bar panel, even though they have perhaps been found to have violated the ethical standards by one or more courts. There's not an effort or intent to exercise authority over courts. Courts enter into agreements and MOUs with other entities, governmental and non-governmental, all the same time. And so I think that it would be a process of determining what the appropriate requirements are. As the state bar staff proposal says, those requirements should be consistency with the rules of court, setting forth the complaint procedure, enforcement of the ethical standards that are called out in the statute, and informing the state bar whether there has been an action taken, what that action has been, so that the state bar can decertify or take other appropriate action against a practitioner who has been found to have violated the ethical standards. I think that, I think there's several options available to the working group. One is the proposal made by Ms. Kopeikin and Ms. Hodgson, which would exempt courts. The state bar office of the general counsel has provided guidance that that would not be consistent with the state bar's obligation, and that would therefore likely result in an alternative staff recommendation to the Board of Trustees. The staff recommendation tries to set out what would be the general terms of an agreement. And if that's not acceptable, I think another approach would be just to do nothing and to leave the process as it's set forth in the rules that were adopted by the working group on April 23rd for complaint procedures. And a third proposal would be to say that the complaints could be heard either by the state bar or by a court or a professional organization designated by the state bar. So thank you.
Okay, thank you. Would anyone else like to be heard regarding this? Yes, I see Ms. Kopeikin's hand up.
Yeah, just one really brief point on the state bar, the suggestion that we could enter into an MOU. Remember that Ms. Hodgson and I are here because of our expertise with the state courts, and we did not mean to suggest that Mr. Weiner doesn't have expertise working within the courts on court processes that are fully embedded in the courts. We recognize that he does. This is a fish of a different kettle of fish, to mix my metaphors. We're talking about an external process overlaying a state one. The second thing that I wanted to say is that I don't think we are not capable of entering into an MOU in this working group. Ms. Hodgson and I don't have that level of authority for our individual courts, much less the courts writ large. But also for the federal courts, I think that entering into such an agreement likely would be an impermissible delegation of constitutional authority to manage their dockets. So I don't think we could do that. I don't know, but that's my understanding from just a cursory look at the law myself. Thank you so much.
Okay. Mr. Pilevsky.
There's two questions. This complaint process only applies if the state courts or the courts choose to be certified, right? So if they choose not to be certified and just run their own programs, that's not an issue. And then, if that's right. And then the second thing for Alan, what do you think about if we go with the state bar proposal, instead of reporting every complaint received, any violation of the ethics rules? So only report something that would otherwise be reported if it's a violation of ethical standards.
Sure. If I may quickly respond to both of those questions, I think that this issue does involve courts that are not certified provider organizations, as well as those that might be. The issue is really who hears the complaints about a certified mediator who is on a court panel where the complaint emanated from the court panel. So that's an answer to your first question. And I think that reporting for courts to only report complaints that found an ethical violation would be workable.
May we also respond, Judge Pichon?
Oh, let's see. Wait, who was speaking?
I'm sorry, Jill Kopeikin.
Okay, the question was directed at Mr. Weiner.
I didn't realize that. I apologize. Go ahead.
All right. Mr. Tuckman.
Thank you. I have a question. Is maybe institutional or more categorized as governance. But the options that have been presented are not really policy choices of the type that we've been discussing for many, many weeks. They really are legal disputes about state bar authority under Business Professions Code, particularly as it relates to court-connected ADR proceedings. So both the proposal to just categorically exempt court-connected ADR complaints and the I'll say the state bar position, they both rely on these interpretations of statutes, confidentiality rules. I don't want to suggest this is a constitutional crisis, but it sounds a little bit like separation of powers, right? And principles. And I have a question. This working group was put together under a statute. And I think that we are limited in some ways by the bounds of that statute. Is this group that is deciding these policy questions the right group to decide this legal issue? And if the answer is yes, we'll vote on it, we'll come up with a solution. But I do want to ask that question, and maybe it's a difficult one, but is there some other entity or process to resolve this type of legal issue? Are we supposed to adjudicate it, or is there another forum? We don't want to pass this, and I don't know what happens. I hope there's not litigation and things like this, but that wouldn't be great for the program. So I'm just asking at this point, is there some other forum that resolves this problem? Because it feels very different from the other issues we've been discussing.
Okay. Ms. Kopeikin, I saw that you shaking your head. So if you can be very brief, please respond. But there are also other hands up. But go ahead, Ms. Kopeikin.
Sure. I think that, Mr. Tuckman, I agree with you. I think this is a completely different kind of issue. It warrants some really serious consideration, possibly going back to the state legislature and saying, did you intend to disrupt existing statutory and constitutional, delegations? And I think that might be the right answer. Sarah Hodgson and I have been looking at just basic statutory principles of, where a statute is silent on things, you don't interpret a conflict, right? So you don't find a conflict and create a conflict where there isn't one. So the statute by its terms does not disrupt our programs and does not in effect with them. So interpreting them differently, that's where we come from. But I certainly agree that I don't think we have the authority as a working group to overrule statutory requirements that are in place in the state and federal courts.
Okay.
That answers your thought, but.
All right. I see Ms. Curtis and Ms. Mia Ellis. So Ms. Curtis, I think your hand was up first.
Okay. Well, I appreciate that there are jurisdictional questions and legal questions that we, may come into play here. But I'm wondering, and this is really a question for you, Jill, the recommendations that we've come up with as a working group do, I think it was in the complaint area, say that the state bar can hear complaints, or that other entities that are designated by the state bar or something like that. So I'm wondering if just simply saying that it's okay for courts to under the scheme that we're coming up with, it's okay for courts to manage these disputes. And as I understand it, there's not a problem with syncing those. They already are pretty much synced. I know in state courts they are for superior court cases anyway. So that's one question. Can it just be that you're permitted by the state bar without saying you're delegated? I don't know, get the language right. The other question that I have is, I know that we already have the onus on people that are where complaints have been filed against them and adjudicated against them. They're already required to report them, and they're just bad actors if they're not. So, and I know that we want to protect the public, but is it better to kind of throw out the court program participation if we're looking at a balancing of the interests in protecting the best we can, the most consumers, having people participate in this program, or shutting down the courts because we have maybe one or two, maybe not even any, bad actors who haven't self-reported.
Thank you. And Ms. Mia Ellis?
Yes, thank you, Judge Pichon. Very briefly, I just wanted to, and this goes to Mr. Tuckman's question, and just as a reminder to the working group, is that the working group, these are the recommendations from the working group, will go to the board, and the board ultimately will be making these decisions. The statute does require the program to have a complaint procedure, and so whether it's the state bar designated or a professional organization designated to hear those complaints, that is part of the statute. So we want it to be resolved within this working group as part of recommendations. But to your point of concern of overstepping, this will go to the board, the working group's recommendation, as well as if there is an alternative staff recommendation. So I just wanted to remind the group of that.
Thank you. And Dr. Getz?
Yeah, I just wanted to echo sort of Mr. Tuckman's comments that this does feel like a statutory interpretation, at least the way it's been presented to us. I don't think that's really where our group is being asked for its expertise. And I'm just wondering out loud if there's, and I heard Ms. Cruz at our last meeting say, can't we thread the needle on this? And I've heard others, and I address this to Ms. Kopekin and Ms. Hodgson. Is there any in between that would be absolutely acceptable to you? I mean, there's an obvious, I think it's been sort of suggested that the court be the exclusive hearer of the complaints, which would solve sort of that issue, but that they would have to report it then to, the state bar. I mean, some more elegant language than that we can come up with. But I'm just saying, wouldn't that be the more obvious thing that we could opine on as a working group rather than a statutory interpretation that the court is exempted from the procedure?
Okay, thank you. Ms. Cruz? You're on mute, Ms. Cruz?
I'm frozen.
Oh, yes. Okay, so we'll go on to.
I'm just going to piggyback on Jack's question and then turn it over to. Can you hear me now?
Yes.
Okay, just to piggyback on Jack's question, did the three of you consider, for example, in listening to some of the objections from last time and this time, some kind of voluntary relationship without an MOU, maybe where you get to do all the complaints and then you require participants to self-report. And if they don't, then the presiding judge can do what they want. But of course, the presiding judge is going to send it to the state bar if you were required to report it and you didn't, right? And there's a finding. Things like that, like where you can take all of your objections and sort of work a way through. So the state bar hears about verified complaints, but doesn't hear about all the little noise that you take care of, in the court system.
Thank you. Ms. Hodgson?
I'd just like to very quickly respond to some of the most recent comments. Agree with all of you that are saying that this is really a statutory interpretation question. And it is not for lack of trying or interest in trying to thread the needle. And Jill and I have continued to work to try to come up with other ideas, something that we think might be amenable to both courts and state bar. I think Jill's going to share that like in the chat or separately soon. It's in the chat now for your reference. I think, setting aside entering into MOUs, anything like that, which frankly, as general counsel, I would not recommend my court do. And I can't speak for the other superior courts. Because that would still be oversight or us assuming like work on behalf of the state bar, which I also think is perhaps beyond the court's jurisdiction. There is no statutory requirement for the courts to report certified ADR practitioners. So to impose that inherently violates the rule of court because the rule of court requires the presiding judge to exercise discretion. And a requirement is not discretion, is not an exercise of discretion. And that's my primary concern with that requirement. It's not that we're trying to hide anything or keep anything, but I think to Ms. Curtis's point earlier, we're already asking the certified practitioners to self-report. We could certainly ask the complainant who would be informed of the outcome of their complaint to also report to the state bar as another kind of catch-all. But to remove the rule of court's delegated discretion to the presiding judge is a serious concern of mine.
Thank you. And Mr. Weiner?
Yes, thanks. And I'll just be very brief here. We do anticipate in the administrative recommendations, we do say that the practitioners are going to need to report if they are found to have, committed a number of transgressions. My understanding of the experience of the state bars, attorneys are also required to do this and very often don't. And that results when the state bar finds out, it results in sort of compound complaints, administrative complaints against the attorneys. So while that could be part of the solution, I think we don't feel like it's the total solution. I think it's not a question of, or this group shouldn't be making a decision of interpretation of the statute, but should be deciding what's best for the policy, whether policy of the certification program, whether that be what Ms. Kopeikin and Ms. Hodgson are recommending, whether it be what staff is recommending, or whether it be something else. Please just make the best policy recommendation that you can. If the State Bar Board of Trustees disagrees, they'll make a different decision.
Ms. Kopeikin?
Yeah, just briefly, I just want to reiterate that if you look at the face of the statute, it requires firms, practitioners, and providers to certify that they have a complaint process in place. It does not mandate this process. We have mandated processes. So Ms. Hodgson and I are trying to propose things that do not violate either of these principles. One, we agree that it was lovely and it was a good idea for us to set up complaint processes, particularly for those who are smaller sole practitioners who otherwise wouldn't have them. We think that's a great idea. But there is an existing thing in place that's working in the state courts and federal courts, and that we think that's recognized by the statute. But regardless, so I would invite all of you to look at the statute before you make any decisions about what it should be, and look at the language again, number one. And number two, I did put something in the chat, which Ms. Hodgson and I are both really busy running our various court programs, but we've tried to keep working on it. Maybe that's another alternative. And I know we didn't get it to you, Alan, beforehand. So I'll invite staff to look at it too, but maybe there's something, maybe that's another step in another direction where we recognize the court procedures, and instead of that, maybe that puts the onus back to where the statute actually puts it. Thank you.
Thank you. Dr. Getz?
Yes, I'm putting into the chat also another idea, which only says to all of us that perhaps there are in-betweens here that could be explored rather than taking a vote today on whether or not we believe the statute applies one way or the other. I mean, all I did was take, parts of both of the proposals and put them together. But there's so many in-betweens here. I just would encourage us not to, try to make a statutory interpretation that we're not really qualified to do. Well, maybe qualified, but perhaps we have been asked to do that, and consider whether the groups can somehow get together, and perhaps I'd be willing to make that as a friendly amendment if Jill and Sarah would accept it. But in any event,
Okay.
that's my input.
Thank you for that. And I'm coming to you, Ms. Curtis, but Dr. Getz, we don't have anything before us at this time.
Okay.
No one has made a motion. So, Ms. Curtis.
Yes, I have a question. I guess, Ron, you would, or staff would be, it would be appropriate for you to answer this. But there is actually a requirement that there be complaint procedures in place, and that and maybe it isn't, maybe it's not to the individual, but if you look at the ethics or the standards of conduct in court-connected cases, which are is the model that we're using, it's there in I forget the 3.8 something on. Anyway, I just wanted to kind of see if I'm grasping the distinction between what you're saying, Jill, and what I understand to be the requirement.
Oh, is that to me?
Anybody who's familiar with the complaint procedure under the rules of California Rules of Court.
Well, I don't like to keep people past their time, but we also, this is a very important discussion. But looking at the proponents of the different views, what is it that you would like the working group to do?
Well, speaking on behalf of myself and the court-connected programs, I agree with many of the sentiments issued here or just raised here, which is this is a really serious issue, and we should not lightly go into, voting on it without, I think, a little bit more opportunity to think about it. I recognize that there were a lot of other important things to address today, but we got to it pretty late, and I think we're all a little tired. I would encourage folks to look at the statute. I would encourage them to look at, and I'll be happy to circulate if it's okay. I would send to the state bar the proposal that we just put in the chat. Maybe we can continue working on that for discussion at the next meeting. So I would ask that we maybe just continue this discussion and perhaps agendize it slightly earlier in the session so that people might have a little bit of bandwidth to deal with that. It's an important topic.
Okay, do you mind reading what you put in the chat as the proposal?
Not at all. The working group recommends that the State Bar adopt a rule that certified ADR practitioners participating in court-connected ADR processes with complaint processes that are substantially similar to California Rule of Court 3.865 at SEC satisfy the requirements of Business and Professions Code Section 6173. As such, complaints for such court-connected ADR processes should be directed to raise complaints arising out of court-connected ADR with the connected court and to inform the State Bar of the outcome.
Okay, well, that is a lot. So that is something that will take a considerable thought and further discussion. So is that what you're proposing, Ms. Copagan, to um, give the group, the working group, more information about your position and then have them think more about it for the next meeting and indicate that that will be your position at the next meeting?
I think that would be, if that's acceptable to Ms. Hodgson. We've worked on this together, but we're continuing to try and iterate with you all. So that would be my proposal.
I would
Okay.
second that proposal.
Okay.
And, you know, I also want to make clear that Ms. Copagan and I are continuing to be willing to work with State Bar staff. Our making this proposal and seconding it is not an indication that we're not willing to continue that work, but we also want to have something before this group.
Okay. All right. So to be clear, the group does not have any motion before it. The request is that we take some more time with this and that Ms. Kopake and Ms. Hodgson stay in touch with staff and see if there is something that can be worked out that the group can vote on. Is that agreeable?
It is to us, Your Honor.
Okay. Mr. Weiner and Ms. Ellis?
Yes, of course. Thank you.
Okay. All right. Is there anything else that you would like to discuss? Like I said at the beginning, we want to give everybody enough time. We want to give each of the subgroups enough time for their presentations. So we don't want to cut anybody off. So I feel bad when I'm telling you how much time you have left, but it is for a reason so that everybody can be heard. All right, Mr. Weiner or Ms. Ellis, I'm going to turn to you for last comments.
I just thank the working group for all of your attention and all of the commitment of time that you've put in, and regrettably, the commitment of a little bit more time going forward. I think the completion of the proposal is on the horizon, and I think we all look forward to that. Thank you.
Okay, and would anybody like to state when our next meeting is, or should we just wait to hear?
The next meeting, January 12th.
Okay.
I don't think I'd it'll be very hard for me to make that meeting.
Oh, I'm sorry to hear that. Anybody
I
else?
can make the next one, the 21st.
Yeah,
Okay.
I am mostly booked up in arbitrations for the entire month of January.
Wow.
Yeah, not the entire month, but all the dates that were put out in the original poll. However, a lot of times cases do
That's true.
sudden death settlements or get continued. So I have the dates on calendar in case the dates do open up, but my regrets if I can't join you.
Okay, thank you.
I'm in the same boat, Judge Fushon, but I'm hoping for an early Hanukkah gift and that a lot of my cases will settle. And I just wanted to wish everybody a happy holidays and to thank staff, especially Angela and Mia and Alan for all their hard work.
Yes, thank you so much. I'm totally grateful for all of the hard work of staff, and I do wish everybody a wonderful holidays. And Mr. Weiner, I see your hand is up.
I was just going to say that invite all of the members of the working group, if you can review the meeting materials ahead of time and provide input to staff, we can share it on your behalf if you're not able to attend the meeting.
Oh,
yes.
great.
Thank you.
Can we vote via email, or is that not?
No, it has to be live.
Okay, and you can't give someone your proxy.
No.
Sadly, no, I tried that once.
Okay, everyone. Thank you so much for your time and your wonderful participation. And please, if there's anything in the interim, please let staff know and we will share it with everyone. So I look forward to speaking with you again January 12th and have a wonderful holidays.
Happy holidays.
Bye.
Thank
Happy
you.
holidays.
Happy holidays.